right, do you have copies for the jurors?
Yes, sir, I do.
Members of the jury, you've heard the evidence and the arguments of counsel. The court and the jury have separate functions. You decide the disputed facts, and the court provides the instructions of law. It is your sworn duty to accept these instructions and to apply the law as it is given to you. You are not permitted to change the law nor to apply your own conception of what you think the law should be. It is your duty to decide the questions of fact in this case. It is my duty to give you the rules of law you must apply in arriving at your verdict. You must follow and apply the rules of law as I give them to you, even if you believe the law is or should be different. Deciding questions of fact is your exclusive responsibility. In doing so, you must consider all the evidence that you've heard and seen in this trial, and you must disregard anything you may have heard or seen elsewhere about this case. I have not by these instructions, nor by any ruling or expression during the trial, intended to indicate my opinion regarding the facts or the outcome of this case. If I have said or done anything which would seem to indicate such an opinion, you are to disregard it. This case began with the filing of an indictment. The indictment informs the defendants that he or she has been charged with an offense. The fact that it was filed may not be considered for any other purpose. The defendant is presumed innocent. This presumption continues throughout the entire trial unless you find it has been overcome by the evidence beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of the offense charged in the indictment. The burden is upon the state to prove beyond a reasonable doubt every essential element of the offense charged. The term reasonable doubt is defined as follows. Reasonable doubt is present when jurors, after they have carefully considered and compared all the evidence, cannot say they are firmly convinced of the truth of the charge. It is doubt based on reason and common sense. Reasonable doubt is not mere possible doubt because everything relating to human affairs or depending on moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his own affairs. After a full and impartial consideration of all the facts, if you have present a firm conviction of the truth of the charge, the state has then proven its case to you beyond a reasonable doubt, and you must then find the defendant guilty regardless of your personal feelings or however distasteful such verdict may be to you. It is your sworn duty to render a true verdict. However, if you do not have such a conviction to the truth of the charge, you must then find the defendant not guilty. Again, no matter what your personal feelings may be on the law which applies in this case, it is your sworn duty to return a true verdict. Evidence is all the testimony received from the witness and the exhibits admitted during the trial and facts agreed by counsel and any facts which the court requires you to accept as true. Evidence may be direct or circumstantial or both. Direct evidence is the testimony given by a witness who has seen or heard the facts to which he testifies. It includes exhibits admitted into evidence during the trial. Circumstantial evidence is the proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts which naturally and logically flow according to the common experience of mankind. To infer or to make an inference is to reach a reasonable conclusion of fact which you may, but are not required to make, from other facts which you find have been established by direct evidence. Whether an inference is made rests entirely with you. Direct evidence and circumstantial evidence are of equal probative value. The evidence does not include the indictment, opening statements, or closing arguments of counsel. The opening statements and closing arguments of counsel are designed to assist you. They are not evidence. Statements or answers that were stricken by the court or which you were instructed to disregard are not evidence and must be treated as though you never heard them. You must not speculate as to why the court sustained the objection to any question or what the answer to such question might have been. You must not draw any inference or speculate on the truth of any suggestion included in a question that was not answered. In this case, you have heard testimony concerning a recording. You have also heard the audio portion of that DVD and have viewed a listening aid of that recording. You are instructed that the listening aid in this case is merely to aid to facilitate listening. The evidence consists of the recording itself. The listening aid is provided to you only for the purpose of helping you understand the recording, if you find they do help you. If you find there's a difference or discrepancy between the listening aid and the recording, you are to rely only on the recording. Again, if you found any difference between the recording and the listening aid, you should disregard the listening aid and use your own judgment as to what was said. You are the sole judges of the facts, the credibility of the witnesses, and the weight of the evidence. To weigh the evidence, you must consider the credibility of the witnesses, including the defendants. You will apply the tests of truthfulness which you apply in your daily lives. These tests include the appearance of each witness upon the stand, his manner of testifying, the reasonableness of the testimony, the opportunity he had to see, hear, and know the things concerning which he testified, his accuracy of memory, frankness or lack of it, intelligence, interest and bias, if any, together with all the facts and circumstances surrounding the testimony. Applying these tests, you will assign to the testimony of each witness such weight as you deem proper. You are not required to believe the testimony of any witness simply because he or she was under oath. You may believe or disbelieve all or any part of the testimony of any witness. It is your province to determine what testimony is worthy of belief and what testimony is not worthy of belief. A number of exhibits and the testimony related to them have been introduced. You may consider whether the exhibits are the same objects and in the same condition as originally taken by the deputies or police officers or special agents. You will determine what weight, if any, the exhibit should receive in light of all of the evidence. The law provides two ways in which criminal responsibility may be placed upon either defendant. First, that the defendant was the principal offender, that is, the defendant did all of the acts which make up all of the elements of the particular offense charged in the indictment. The other way of placing criminal responsibility on the defendant is that the defendant aided and abetted one or more persons in committing an offense or offenses, knowing that he was facilitating the offenses charged in the indictment, or that he or she planned or aided in the planning of the offense, or agreed that one or more of them would commit an act which facilitated the commission of the offense. This is known as complicity. The law allows complicity to be charged in terms of the principal offense, that is, the offense as stated in the indictment, or in terms of the complicity statute, Revised Code Section 2923.03. Either way is sufficient under the law. The state has elected to charge the offenses in terms of the principal offenses. The state has introduced evidence alleging that each defendant is guilty of the principal offenses under the theory of complicity and argued in certain respects each defendant is an accomplice. You may find either defendant or both defendants guilty of any or all of the principal offenses charged in the indictment if you find that the defendant is guilty of complicity with others in those offenses. The offenses will be explained to you in these instructions. You may find either defendant guilty as if he or she or they were the principal offender of any or all of those offenses. If you find that the defendant aided and abetted in the commission of any of or all of the offenses or conspired with others to commit the offenses. Aiding, abetting, and conspiring with others will be defined for you in these instructions. Before you can find the defendant guilty of the principal offenses by reason of complicity, you must find beyond a reasonable doubt that on or about the dates alleged in the indictment in Scioto County, Ohio, the individual defendant knowingly aided or abetted another in committing any or all of the offenses charged in the indictment, or that the individual defendant conspired with another to commit any or all of the offenses alleged in the indictment. Aided or abetted means supported, assisted, encouraged, cooperated with, advised, or incited. Conspired means the defendant with the purpose to commit, promote, or facilitate the commission of any or all of the alleged offenses with another person or persons planned or aided in planning the commission of such offense, or that the defendant agreed with another person or persons that one or more of them would engage in conduct which facilitated the commission of such offenses. You will be given the instructions on the elements of the principal offenses alleged in the indictment, together with the meaning of their words and phrases. It is no defense that no person with whom the defendant was in complicity has been convicted as a principal offender. Complicity may be demonstrated by circumstantial as well as direct evidence. Participation in criminal intent can be inferred from circumstances surrounding the offenses, including presence, companionship, and conduct before and after the offense is committed. Actual participation in the act is not required. In order to find the defendant guilty of the offenses of complicity, the state must show that the defendant shared in the criminal intent or purpose of the principal to commit the offenses. During argument, you heard considerable discussion as to the motives or actions of other persons. If they acted improperly, charges could be brought against them. The only person on trial here is the defendants, and the sole purpose of this lawsuit is to determine whether the defendants are guilty or not guilty. It is not to determine guilt or innocence of other persons on other charges. However, in weighing the testimony, as the court has told you before, you may consider their motives as going to the weight of their testimony, but we are only trying the case of these defendants. One who follows a profession or specialty may express his or her opinion because of his or her education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you to arrive at a just verdict. Questions have been asked in which witnesses were permitted to assume that certain facts were true and give an opinion based upon such assumption. You must determine whether the assumed facts upon which a witness based his or her opinion are true. If any assumed fact was not established by preponderance of the evidence, you will determine the effect of that failure upon the value of the opinion of the witness. As with other witnesses, upon you alone rests the duty of deciding what weight should be given to the testimony of each witness. In determining its weight, you must take into consideration the witness's skill, experience, knowledge, veracity, interest, familiarity with the facts of this case, and the usual rules for testing credibility and determining the weight to be given to testimony. You may consider only expert evidence which is based upon reasonable and scientific certainty or upon a probability. The testimony of the defendants is to be weighed by the same rules that apply to other witnesses. Evidence was received that the defendant, Daniel Groves, was convicted of theft. That evidence was received only for a limited purpose. It was not received, and you may not consider it to prove the character of the defendant, Daniel Groves, in order to show he acted in conformity with that character. If you find the defendant was convicted of theft, you may consider that evidence only for the purpose of testing the defendant Daniel Groves' credibility or believability and the weight to be given his testimony. It cannot be considered for any other purpose. Before you decide whether the state of Ohio has proved beyond a reasonable doubt all the essential elements of the offenses with which the defendants are charged, you must first decide whether this is the correct county in which the trial should be held. The state must prove beyond a reasonable doubt that Dylan Groves' body or any part of his body was found in Scioto County, Ohio. It is not necessary that the state prove the offense was committed on the exact date as charged in the indictment. It is sufficient to prove the offense took place on a date reasonably near the date claimed. You may not discuss or consider the subject of punishment. Your duty is confined to the determination of guilt or innocence of the defendant. In the event you find the defendant guilty, the duty to determine the punishment is placed by law upon the court. The court must consider the laws and statutes applicable to sentencing, which may or may not be relevant to the determination of guilt or innocence. The offenses set forth in each count of the indictment constitute separate and distinct matters. You must consider each count and the evidence applicable to each count separately, and you must state your findings as to each count uninfluenced by your verdict as to other counts. The defendants or either of them may be found guilty or not guilty of any one or all of the offenses charged. Each defendant is charged in count one of his or her respective indictment with aggravated murder. You must weigh each count of the indictment and each defendant separately. Before you can find the defendants or either of them guilty of count one, you must find beyond a reasonable doubt that on or about the 28th day of March 2019 to the 11th day of June 2019 and in Scioto County, Ohio, the defendant or either of them did or as an accomplice purposely caused the death of another who was under 13 years of age at the time of the commission of the offense, to wit, Dylan Groves. Purpose is an essential element of the offense of aggravated murder. A person acts purposely when it is the person's specific intention to cause a certain result, or engage in conduct of a certain nature. It must be established in this case at the time in question there was present in the mind of the defendant a specific intention to cause death. When the central idea, essence, or gist of the offense is a prohibition against conduct of a certain nature, a person acts purposely, regardless of the person's intent to accomplish thereby, if it was the person's specific intent to engage in conduct of that nature. Purpose is the decision in the mind to do an act with a conscious objective of producing a specific result or engage in specific conduct. To do an act purposely is to do it intentionally and not accidentally. Purpose and intent mean the same thing. The purpose with which a person does an act is known only to himself unless he expresses it to others or indicates it by his conduct. The purpose with which a person does an act or brings about a result is determined from the manner in which it is done, the means used, and all the other facts and circumstances in evidence. Purpose or intent need not be proven by direct testimony. Purpose or intent can be established by circumstantial evidence. An intent to kill may be inferred when the natural and probable consequences of a wrongful act is to produce death, where the gist of the offense prohibits the conduct which may lead to death. Intent is not easily proven by direct evidence, but is usually proven by reference to the surrounding facts and circumstances. These surrounding facts and circumstances include the nature of the conduct itself, the tendency of the conduct in life, and the manner with which the wounds were inflicted. In order to find either defendant guilty of aggravated murder, you must find that the defendant specifically intended to engage in the conduct that caused Dylan's death. Proof of motive is not required. The presence or absent of motive is one of the circumstances bearing upon purpose. Whether an act is committed, where an act is a crime, a good motive or purpose is not a defense. Cause is an essential element of the offense of aggravated murder. Cause is an act which directly produces the death of another and without which it would not have occurred. If you find the state proved beyond a reasonable doubt all the essential elements of the offense of aggravated murder, your verdict must be guilty. If you find the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of aggravated murder, then your verdict must be not guilty. Each defendant is charged in count 2 of his or her respective indictment with murder. You must weigh each count of the indictment and each defendant separately. Before you can find the defendants or either of them guilty of count 1, you must find beyond a reasonable doubt that on or about the 28th day of March 2019 to 11th day of June 2019 and in Scioto County, Ohio, the defendant or either of them did or as an accomplice caused the death of another, Dylan Groves, as a proximate result of the defendant's committing or attempting to commit an offense of violence that is a felony of the first or second degree, to wit, felonious assault. You are instructed that felonious assault is a felony offense of violence of the first or second degree. Cause is an essential element of the offense of murder. Cause is an act which directly produces the death of another without which it would not have occurred. Committing or attempting to commit means the death must occur as part of acts leading up to or occurring during or immediately after the commission of felonious assault, and the death was directly associated with the commission of that offense. A criminal attempt is when one purposely does or fails to do anything which is an act or omission constituting a substantial step in the course of conduct planned to culminate in the commission of the offense. To constitute a substantial step, the conduct must be strongly corroborative of the actor's criminal purpose. In order to find felonious assault, you must find, beyond a reasonable doubt, that on or about the 28th day of March 2019 to the 11th day of June 2019 in Scioto County, Ohio, the defendants or either of them did or as an accomplice knowingly caused serious physical harm to Dylan Groves. Knowingly is an essential element in a felonious assault offense. A person acts knowingly regardless of his purpose when he is aware that his conduct will probably cause a certain result, or he is aware that his conduct will probably be of a certain nature. A person has knowledge of circumstances when he is aware that such circumstances probably exist. When knowledge of the existence of a particular fact is an element of an offense, such knowledge is established if a person subjectively believes there is a high probability of its existence and fails to make inquiry or acts with a conscious purpose to avoid learning the fact. Knowingly means that a person is aware of the existence of the facts, that his acts will probably cause a certain result or be of a certain nature. Since you cannot look into the mind of another, knowledge is determined from all the facts and circumstances and evidence. You will determine from these facts and circumstances whether there exists at the time in the mind of the defendant an awareness of the probability that his conduct would cause this result. Serious physical harm to persons means 1, any mental illness or condition of such gravity as would normally require hospitalization or prolonged psychiatric treatment. 2, any physical harm that carries a substantial risk of death. Or 3, any physical harm that involves some permanent incapacity, whether partial or total, or that involves some temporary substantial incapacity. Or 4, physical harm that involves such permanent disfigurement or that involves some temporary serious disfigurement. Or 5, any physical harm that involves acute pain of such duration as to result in substantial suffering or that involves any degree of prolonged intractable pain. Felonious assault is more fully described for you below. If you find that the state proved beyond a reasonable doubt all the essential elements of murder, your verdict must be guilty. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of murder, then your verdict must be not guilty. Each defendant is charged in count 3 of his or her respective indictment with kidnapping. You must weigh each count of the indictment and each defendant separately. Before you can find the defendants or either of them guilty of count 3, you must find beyond a reasonable doubt that on or about the 11th day of January 2019 to the 11th day of June 2019 in Scioto County, Ohio, the defendant or either of them did or is an accomplice by force, threat, or deception, or by any means in the case of a person who is under 13 years of age, did remove Dylan Groves from the place where he was found or restrain Dylan Groves of his liberty for the purposes of hindering, impeding, or obstructing a function of government. The term purposely has previously been defined for you in these instructions. Force means any violence, compulsion, or constraint physically exerted by any means upon or against a person or thing. Threat means a statement or conduct which directly or indirectly exerting pressure sufficient to overcome the will of another to make another feel fearful or apprehensive of injury or harm. Deception means not only deceiving another or causing another to be deceived by any false or misleading representation, by withholding information, by preventing another from acquiring information, or by other conduct, act, or omission that creates, confirms, or perpetuates a false impression in another, including a false impression as to law, state of mind, or other objective or subjective fact. You must decide whether Dylan Groves was under the age of 13 at the time of the commission of the alleged offense. If Dylan Groves was under the age of 13, the manner or means by which the defendant accomplished the alleged act of kidnapping is immaterial. If Dylan Groves was not under the age of 13, then in order to find the defendant or either of them guilty of kidnapping, you must find the defendant's acts of kidnapping was accomplished by force, stealth, or deception. It does not matter whether the defendants knew of Dylan Groves' age. To remove from the place where found means to change the victim's location. This need not be for any specific distance or duration of time or in any specific manner. To restrain one of his or her liberty means to limit or restrain the victim's freedom of movement. The restraint need not be for any specific duration of time or by any specific manner. You are instructed that the Scioto County Children's Service Board is a government agency. If you find that the state proved beyond a reasonable doubt all the essential elements of the offense of kidnapping, your verdict must be guilty. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of kidnapping, then your verdict must be not guilty. Each defendant is charged in count 4 of his or her respective indictment with endangering children. You must weigh each count of the indictment and each defendant separately. Before you can find the defendants or either of them guilty of count 4, you must find beyond a reasonable doubt that on or about the 11th day of January 2019 to the 11th day of June 2019 and in Scioto County, Ohio, the defendant or either of them was the parent, custodian, person having custody or control, or person in place of a parent of a child, Dylan Groves, and did or as an accomplice recklessly create a substantial risk to health or safety of the child by violating a duty of care, protection, or support. Custodian means one entrusted officially with custody. Child means a person under 18 years of age or a mentally or physically handicapped person under 21 years of age. Person acts recklessly when, with heedless indifference of the consequences. The person disregards a substantial and unjustifiable risk that the person's conduct is likely to cause a certain result or is likely to be of a certain nature. A person is reckless with regard to circumstances when, with heedless indifference to the consequences, the person disregards a substantial and unjustifiable risk that such circumstances are likely to exist. The term substantial risk means a strong possibility as contrasted with a remote or significant possibility that a certain result may occur and that certain circumstances may exist. If you find that the state proved beyond a reasonable doubt all the essential elements of the offense of count 4, endangering children, your verdict must be guilty. If your verdict is guilty, you will separately decide beyond a reasonable doubt whether the violation resulted in serious physical harm to Dylan Groves. If your verdict is not guilty, you will not decide this issue. Serious physical harm has previously been defined for you in these instructions. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of count 4, endangering children, then your verdict must be not guilty. Each defendant is charged in count 5 of his or her respective indictment with tampering with evidence. You must weigh each count of the indictment and each defendant separately. Before you can find the defendants or either of them guilty of count 5, you must find beyond a reasonable doubt that on or about the 11th day of January 2019 to the 11th day of June 2019 in Scioto County, Ohio, the defendant or either of them, knowing that an official investigation was in progress or about to be instituted or was likely to be instituted, did, or as an accomplice did, alter, conceal, or remove a thing, to wit, the body of Dylan Groves, with the purpose to impair its value or availability as evidence in the investigation. Purpose and knowingly had previously been defined for you in these instructions. If you find that the state proved beyond a reasonable doubt all the essential elements of the offense of tampering with evidence, your verdict must be guilty. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of tampering with evidence, then your verdict must be not guilty. Each defendant is charged in count 6 of his or her respective indictment with interference with custody. You must weigh each count of the indictment and each defendant separately. Before you can find the defendants or either of them guilty of count 6, you must find beyond a reasonable doubt that on or about the 11th day of January 2019 to the 11th day of June 2019 in Scioto County, Ohio, the defendant or either of them, knowing that he or she was without privilege to do so or being reckless in that regard, did or as an accomplice enticed, took, kept, or harbored from his guardian a child under the age of 18. Knowingly and recklessly had previously been defined for you in these instructions. Privilege means an immunity, license, or right conferred by law, bestowed by express or implied grant, arising out of status, position, office, relationship, or growing out of necessity. If you find that the state proved beyond a reasonable doubt all the essential elements of the offense of count 6, interference with custody, then your verdict must be guilty. If your verdict is guilty, you will separately decide beyond a reasonable doubt whether the child suffered physical harm as a result of the violation. If your verdict is not guilty, you will not decide this issue. Physical harm to persons means any injury, illness, or other psychological impairment, regardless of its gravity or duration. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of count 6, interference with custody, then your verdict must be not guilty. Each defendant is charged in count 7 of his or her respective indictment with gross abuse of corpse. You must weigh each count of the indictment and each defendant separately. Before you can find the defendants or either of them guilty of count 7, you must find beyond a reasonable doubt that on or about the 1st day of March 2019 to the 11th day of June 2019 in Scioto County, Ohio, the defendant or either of them, without being authorized by law, did or as an accomplice recklessly treated a human corpse in a way that would outrage reasonable community sensibilities. Persons authorized by law include a county coroner and designated members of his or her staff, physicians and surgeons, accredited medical students, embalmers certified to remove human organs for transport purposes, transplant purposes, persons authorized to remove certain human organs by consent of the deceased or according to law, and all other persons acting under authority of law. If you find that the state proved beyond a reasonable doubt all the essential elements of the offense of count 7, gross abuse of corpse, then your verdict must be guilty. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of count 7, gross abuse of corpse, then your verdict must be not guilty. Each defendant is charged in count 8, 9, 10, and 11 of his or her respective indictment with felonious assault. You must weigh each count of the indictment and each defendant separately. Before you can find the defendants or either of them guilty of counts 8, 9, 10, or 11, you must find beyond a reasonable doubt that on or about the 11th day of January 2019 to the 11th day of June 2019 in Scioto County, Ohio, the defendant or either of them knowingly did or as an accomplice caused serious physical harm to Dylan Groves. The state charges that the act or failure to act of the defendant caused serious physical harm. Cause is an essential element of the offense. Cause is an act or failure to act which in a natural and continuous sequence directly produces the serious physical harm without which it would not have occurred. The defendant's responsibility is not limited to the immediate or most obvious result of the defendant's act or failure to act. The defendant is also responsible for the natural and foreseeable consequences or results that follow in the ordinary course of events from the act or failure to act. There may be one or more causes to an event. However, if a defendant's act or failure to act was one of those causes, then the existence of other causes is not a defense. The defendant is responsible for the natural consequences of the defendant's unlawful act or failure to act, even though serious physical harm was also caused by an intervening act or failure to act of another person. Knowingly and serious physical harm have previously been defined for you in these instructions. If you find that the state proved beyond a reasonable doubt all the essential elements of the offenses of felonious assault, that would be as included in counts 8, 9, 10, and 11, then your verdict must be guilty. If you find that the state failed to prove beyond a reasonable doubt any one of the essential elements of the offense of felonious assault, your verdict must be not guilty. You have heard evidence that the defendants were intoxicated at the time of the offenses charged in the indictment. Intoxication is not an excuse for an offense and may not be considered by you in determining the existence of the mental state of the defendants at the time of the offenses. Intoxication does not relieve a person of a duty to act. Testimony has been admitted indicating that the defendants fled the scene and attempted to conceal the body of Dylan Groves. You are instructed that the fleeing from the scene or attempting to conceal the body of Dylan Groves do not raise a presumption of guilt, but it may tend to indicate the defendant's consciousness of guilt. If you find the facts do not support that the defendants fled from the scene or attempted to conceal the body of Dylan Groves, or if you find some other motive prompted the defendant's conduct, or if you're unable to decide what the defendant's motivation was, then you should not consider this evidence for any purpose. However, if you find that the facts supported the defendants engaged in such conduct, and if you decide that the defendants were motivated by a consciousness of guilt, you may, but are not required, to consider that evidence in deciding whether the defendant is guilty of the crimes charged. You alone will determine what weight, if any, to give this evidence. The defendants have entered a plea of not guilty, and this puts in issue all of the essential elements of the offenses, and before the defendants can be convicted, each and every element of each charge must have been proven beyond a reasonable doubt. When you have reached a verdict, you will all fill out the verdict forms that correspond with your decision. All members of the jury shall sign the verdict form in ink. The foreman shall sign the verdict form twice, once as a juror and then as a foreman. You should not discuss or consider the subject of punishment in your deliberations. Your duty is confined to determining the guilt or innocence of the accused. It is the court's function to determine punishment should you find the defendant or either of them guilty. Now, ladies and gentlemen, I'm going to entrust to your care during jury deliberations 44 verdict forms. I've got 22. First, in the case of State of Ohio versus Daniel Groves, 19 CR 586A. I'm going to read the first two of those to you. It says, we, the jury, having been duly impaneled, find beyond a reasonable doubt the defendant Daniel A. Groves guilty of count 1 of the indictment, aggravated murder in violation of Ohio Revised Code section 29, 2903.01CFA, being an unclassified felony. Form right under that says, we, the jury, having been duly impaneled, find the defendant, Daniel A. Groves, not guilty of count 1 of the indictment, aggravated murder in violation of Ohio Revised Code, section 2903.01 CFA, being an unclassified felony. You'll have one guilty and one not guilty verdict form for Mr. Groves, guilty and not guilty for each count of the indictment. Now remember, during these instructions, I had indicated to you that in count 4 and in count 6, that if you do find the defendant guilty beyond a reasonable doubt, you will continue to make further findings. If you do not find him guilty as to count 4 or count 6, then you will not consider those additional findings. Now, as to the defendant, case styled State of Ohio versus Jessica Groves, 19 CR 586B. You also have 22 verdict forms, 2 for each count of the indictment. Once again, I'm going to read the first 2 for you here. First one says, we, the jury, having been duly impaneled, find beyond a reasonable doubt the defendant Jessica Groves guilty of count 1 of the indictment, aggravated murder, in violation of Ohio Revised Code, section 2903.01 CFA, being an unclassified felony. Second verdict form says, we, the jury, having been duly impaneled, find the defendant Jessica Groves not guilty of count 1 of the indictment, aggravated murder, in violation of Ohio Revised Code, section 2903.01 CFA, being an unclassified felony. Once again, you'll have guilty and not guilty forms as to each count of all 11 counts of the indictment. Do not be influenced by sympathy. It is your sworn duty to carefully weigh all of the evidence, decide all disputed questions of fact, and to apply the instruction of the court to your findings and to render a just verdict in accordance with the laws of this state. In fulfilling this duty, your efforts must be to arrive at a just verdict. Consider all of the evidence, make your decision free of bias or sympathy so that both parties feel that their cause was fairly and impartially tried by you. Upon entering the jury room, one of your first duties will be to select a jury foreman or forelady. Having done so, it is not wise to immediately express a determination to insist upon a certain verdict because you may hesitate to change your position even if you find that you are wrong after having further consulted with your fellow jurors. Each of you must decide in this case for yourselves, but you should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you are convinced you are wrong. However, do not change an honest opinion in order to be congenial or to accommodate other members of the jury. Will counsel please approach? Pointed out to me on page 12 of your instructions, under count 2 murder, on the third line, right, it says count 1, that should be count 2. So it should read, each defendant is charged in count 2 of his or her respective indictment with murder. You must weigh each count of the indictment, each defendant separately, before you can find the defendants or either of them guilty of count 2. You must find, so you'll make that correction on your copy of the jury instructions. In the original selection of the jury, we selected 4 alternates to serve in the event of any mishap of one of the other jurors. At this time, Ms. Hatton, Ms. Wallace, Mr. Dehart, and Ms. Haas. At this time, you are excused from further service. It is necessary under the law that I admonish you that you are not to discuss this matter or tell anyone about your verdict, what your verdict would have been had you been called upon to replace a juror. After the jury is dismissed or a verdict has been returned, you are free from this instruction. Now, ladies and gentlemen, as to the alternates, I am not going to discharge you at this time. You are free to go. You're free to go home or back to work or where you need to go, but I will need you to leave your cell phone number with the bailiff in the case you will be called upon to return to the court in case of a mishap during deliberations with one of the selected jurors. Just make sure Mr. Hutchins or Mr. Bryan get your cell phone number before you leave. Court will now place in your possession the exhibits and the verdict forms. The foreman or forelady will retain possession of these documents and return them to the court when you have arrived at a verdict. Until your verdict is announced in open court, you are not to disclose to anyone else the status of your deliberations or the nature of your verdict. After having retired to the jury room and after having selected the foreman or forelady, you should immediately begin your deliberations. When all 12 of you, and I repeat, all 12 of you have arrived or agreed upon a verdict, you will sign the verdict in ink and signal the bailiff. You will then be returned to the courtroom to render your verdict. Ladies and gentlemen, at this time I'll release you to the custody of the bailiffs to take you and the evidence and verdict forms down to the jury room. Alternates are excused but not discharged. So those go down.
Everybody, at this point in time, take your notebooks with you. This is 22 seconds. And everybody can go to the jury room.
Off the record.